My name is Connor Marshall, and the topic that I decided to report on is boarding facility liability. Um, the reason that I chose this topic is because my parents started a horse boarding facility as a part-time, I guess I would say, hobby and business venture when I was relatively young. So I thought it would be a good thing to educate myself on, depending on if we're still operating the boarding stable at that in the future. So I did a little research online as well as what we do at our own stable to come up with a presentation to educate the class on uh, some of the language and terms and contracts that are pretty standard in terms of boarding horses at a stable and what that's like for the owner of the horses and the owner of the stable itself. So to begin, the overall nature of horse boarding, um, as we all know, can be dangerous and difficult from a liability standpoint. Both the horse and rider are subject to dangerous situations, and this is an important topic to understand. In the equine realm, regardless of if whether you're boarding a horse or if you own a stable, it is a dangerous practice. I mean, by nature, animals of that size can cause considerable damage to property, people, children, you name it. So going into a business venture or a boarding contract, it's necessary to be aware of these types of things. And I think the reason I put this on here is that it's the most important, I think, statute. For instance, in Colorado, where I'm from, we have this posted at the stable, as well as I've seen it posted at other stables. When I was at Colorado State, I participated on the polo club. I remember this being at the equine facility at CSU as well. It's important to understand this statute. It says that under Colorado state law, an equine professional, meaning the stable owner or trainer or whatever it might be, is not liable for an injury or for the death of a participant in equine activities resulting from the inherent risks of equine activities, pursuant to Section 132119 Colorado Revised Statutes. I think the key language to absorb here is number one, equine activities, equine professional, and inherent risk. We'll talk a little bit more about that later, but this is a pretty important topic to discuss. So terms, I guess going into boarding facility or I guess this nature in general, it's really important for the owner of the horse to be familiar with the boarding services and terms of agreement of the stable that they wish to board at. So the terms of agreement are definitely a key role. And these are just some of the basic outlines of basic terms and services that a horse boarding facility takes note of. Number one is the health of the horse. Obviously, people want their horse to be in a safe and healthy environment. Also, touch base on if there's injury or death to the horse, which ideally there would not be, but we all know that that's not always the case. So if and then what to do when the horse is injured or dead. Emergency care, hoof health, rules of the particular barn, whether it's just arrival, hours of operation, certain activities, etc. Personal injury, guests, and who that liability falls on. It's definitely good to know the fees involved, what will happen if you fail to pay your fees, termination and of the contract, equipment, damage to facility, children and supervision, definitely important, and contact with other horses, meaning can another boarder ride other people's horses? Can your horse be in the same stable as other horses? There's definitely plenty of verbiage that can fill in a lot of these categories, but regardless, these I think are the very basic and important things to cover, whether you own a stable or planning to board at one. So to begin, I think the most liability falls on personal injury if a stable owner is not careful. It's critical to establish the liability of personal injury to avoid prosecution. So by clearly defining barn activities, rules, and circumstances of an injury should be part of the contract so that customers understand their role and yours. This is often the biggest risk that a stable faces, so it's important to tackle the details and legality of this first, which I totally agree with in terms of land ownership, business relationships. Personal injury is definitely an important thing to. I mean, the horse can't sue the stable necessarily, but the person can. So I believe that's something that comes first. I'm going to go over a few quick definitions that a lot of people might seem very obvious, but when you're writing legal contracts, particularly in this situation, it's definitely key that people understand what you mean by the term barn. You, we, horse, boarder, or boarders, so that as you explain to people in the contract, there's a firm understanding. So it's pretty fairly obvious here. The barn is a property, facilities where a horse you have been given permission to ride or is being boarded. You or your refers to the rider or guest. We or us as the property owner. Horse or horses that have been given permission to ride by us or any of our boarders. Any person that is contracted to provide boarding services for them. I apologize, I'm going to grab a charger really quick from my computer. Give me 1 second. I apologize for that. Believe it or not, broadcasting this takes quite a bit of battery, so I didn't realize how low it was. So I think something else that was really important was barn rules. And this is something that came from my parents' contract. So as I stated before, they make it very clear who you and us and we are. So it states here that you agree to follow and obey the rules of the barn. You will adhere and obey the changes to the barn rules as they are posted frequently. If you violate the rules of the barn, we can terminate your contract with the barn and can immediately evict you and your horse from the barn. Definitely good leverage to have to begin with so that people know they are subject to eviction if they don't follow the safety rules and so on and so forth. This is hugely important, as I talked about personal injury. You will hold us harmless, which I think is a key word, is why I underlined it, to any and all injury to you while at or on the barn facility or any other location not part of the barn resulting from any cause. You agree that you agree. I apologize for the typo. You're being provided access to the barn for purposes of equine activities, which are inherently dangerous activities. I think this is also extremely key, inherently dangerous activities. Everyone that's involved in equine should know that it's a dangerous activity, and therefore the barn or land owner that is leasing the property or boarding facility is not necessarily responsible for injuries because it is obviously and inherently dangerous. You accept the risk of equine activities and the responsibility for injury to you while at the barn or any other locations. If you are granted access to a landowner's property through association with the barn, you hold these property owners harmless to any and all injuries resulting from the cause. The last sentence of this I think is important because, for example, at our stable, people are allowed to ride through other landowners' property to get to certain destinations like the state park or various other areas, and it's key to know that they cannot sue the other landowners when they're riding on other property, as that can be confused or a loophole, but it clearly states that riding on associated property also is considered harmless. Another key subject I thought was worth noting on is horse leasing. Leasing a horse in a stable requires much agreement. Many but not all riders own a horse. So as a result, some stable owners or horse owners or even riders at the stable can lease their horses to another rider at a fee, which seems really easy. I mean, it could be an easy exchange. Hey, you can ride my horse, use my horse for compensation or for a favor. Although it's not a terribly complicated agreement, I think that there should be more than just verbal commitment or a handshake in this case. If someone else is riding your horse or on that property, or vice versa, it's good to know who's liable for what and why that is, particularly because a lot of people who don't own the horse can be a little bit uneducated or unsuspecting of the danger. So it's a good thing to get that into writing. It's important because the health of the horse and the rider should be accounted for. As stated before, equine activities are high risk, so it's important for both the horse and the horse owner and the rider to understand the liability fully before leasing a horse. Last but not least, I wanted to touch base on the insurance that's involved with having a horse boarding facility. Much like a lot of other agricultural operations, there's definitely a lot of liability and adherent harm that can be caused on a farm or ranch, but particularly in horse boarding, you deal with so many clients, so many customers versus employees actually. But as we talked about, the inherent risk in equine is very high. So, the policy for a stable is very important because the volume of injury and death is definitely higher as well. So going into it, it's good to have the proper insurance for sure. For my discussion question, I thought it would be interesting to see, just for the sake of discussion, which practice is more liable, dog boarding or horse boarding, and why? Do you think there's more regulation on one or the other? The reason I ask this is because it's actually a really good question, but also my girlfriend who I met at CSU's father has a dog boarding kennel, and my parents have a horse boarding kennel as part-time business ventures. And they seem very, very similar, but they also have different qualities to them. So I thought it'd be interesting to see what people thought or even research if there's more liability or more regulation involved in which one. So that's my current discussion question. For the exam questions, I thought a good essay question would be, in a boarding situation, who do you find more responsible for liability? And why do you think that? It seemed fairly obvious that the stable owner is more liable because they've taken on the liability and the insurance and have the responsibility of contracting those things. But you also got to consider that the rider or the boarder themselves should be responsible too to think about these things going into it. And if you're not dealing with a very professional stable, you could easily lose a horse, become injured. There's a lot of things that could happen to you in a financial and health standpoint that if you're not careful, you wouldn't necessarily want to be liable for. You could enter into a situation that's not favorable. So I think there's a lot of responsibility that falls on both sides. So I thought it'd be interesting to get people's opinion on that as well. For the multiple choice, I thought a really key point, like I underlined before, what is the key term the equine profession that allows equine professionals not to be liable for injuries in the state of Colorado? Obviously, as a multiple choice, there would be different options, but the clear answer here that would be in the multiple choice is that the inherent risk is the key term. Like we talked about in a few of the other lectures and the guest lecture with the National Western Stock Show, some of those examples, people riding and being involved in livestock or equine activities, there's obvious and inherent risks that come along with that. So I think that is the absolute key term as to why an equine professional should not be liable for injuries on the property or involved in equine activities. So that's all I have. I thought this was a great topic to talk about because I'm partial to it. But I also had a lot of resources to tap into, whether it was at CSU or at home or online, of course. But I hope to get some good feedback from this, and maybe some people can answer these questions or are also partial to it. So I appreciate your time, and thanks for listening.